Mr. Redden, is there anything you want to say on your own behalf before I pronounce sentence? Have you looked at your criminal history?
Actually, just I looked at it.
I mean, you lived it, I
I
suppose.
just looked at it, yeah.
Yeah. Shape that, but I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Addis.
Do lower court rulings really matter? Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. If you like channel, like content, and what I do, you can support me with the link. Everything is appreciated. And once again, the store is open. Use code CGB20 will get you 20% off free shipping. Connecticut residents, I am sorry you have to pay the sales tax. I have no say over that matter. But CGB20 will get you 20% off. Move out this winter stuff at a good price, get some cool gear, and I can move in my summer stuff. But let's talk about this. And there are two cases that right now that just had rulings from lower courts. And I see a lot of people kind of, well, to be frank, pissing and moaning about what the courts did. But looking at where these courts are located, I'm thinking to myself, how can you be shocked? Why are we surprised that a court in a very liberal blue Democrat area comes out with a ruling that goes against the Constitution? Why are we so shocked? We know that judges, for the most part, do not rule based on the Constitution. They do not rule on its wording or its meaning. They rule based on their partisan bias also. That comes into play. So why are we shocked? Now, like I said, there are two cases that have happened. Washington State, Democrat-run bastion. The Supreme Court upheld the ban on high-capacity magazines. I'll bring you in here, and we'll just breeze over it because I want to just make a point. But the Washington Supreme Court on Thursday upheld the state's ban on the sale of gun ammunition magazines that hold more than 10 rounds. This is a law that went out in 2022. Kelso's gun shop in Washington State challenged it, saying that it violates the individual rights of the citizen to arm and defend themselves. Supreme Court in the 7-2 ruling said, nah, we don't buy that because they claimed that high-capacity magazines aren't arms. Even though in a semi-automatic firearm, the magazine is a vital component of the function of the gun. We know this. But just a component of a gun and not generally used for self-defense. The ruling tracked with arguments attorneys for the state made before the court in January. Quote, by restricting only magazines of a capacity greater than 10, the statute effectively regulates the maximum capacity of magazines, leaving the weapon fully functional for its intended purpose. Justice Charles Johnson wrote in Thursday's opinion, indeed, we can safely say that individuals are still able to exercise the core right to bear arms when they are limited to purchasing magazines with a capacity of 10 or fewer. That's fine, but the problem is that these guns were designed around a specific magazine capacity. The only reason that 10-round magazines are even made is because some states pull garbage like this. The gun was designed for 15 rounds. In the case of, let's pull one out of the air, Glock 19, it was designed around 15 rounds. They only make it 10 because states do this, just to make the gun accessible to people in that state. Doesn't mean that somehow the functionality of the gun is going to change. But its effectiveness in a self-defense situation is hampered by the fact you have fewer rounds. It's just common sense. Same thing with the AR-15. It was designed around a 30-round magazine. That's how it was built. That's how it should be sold, and that's how it should be used. Once again, they only have 10-round magazines because states like this. Attorneys for Gators Custom Guns, including former Republican Attorney General candidate Pete Serrano, I'd argued that the popularity of high-capacity magazines inherently provided they abide by the U.S. Supreme Court ruling protecting firearms that are in common use, and in common use with an AR-15 is an item that carries a 30-round magazine. That's the standard for it, and are typically possessed by law-abiding citizens for lawful purposes. They're claiming that because you can still technically use the gun with a 10-round magazine, it doesn't infringe on the Second Amendment. But once again, why are we shocked that a lower court in in a liberal bastion in a blue state goes against the Constitution. Why should we be shocked about that? But the other case I want to bring up is case in Massachusetts. The first district in Boston has just ruled that the state's assault weapons ban is constitutional. And I read the article on this, and the argument is going to blow your mind, because I was just like, wow, I can't believe he actually said that. But Federal Appeals Court confirms constitutionality of state's assault weapons ban. Remember, this is the first U.S. Circuit Court of Appeals in Boston. But they claim that the assault weapons ban is constitutional, and their biggest argument, I'm going to come down to here, these justices actually cited Bruin in their argument to saying that it is constitutional. They claim that Massachusetts statute aligns with historical precedents where specific weapons were banned once their potential danger to public safety was evident. Noteworthy examples include prior regulations on trap guns, long-bladed knives, blunt instruments, sawed-off shotguns, and machine guns, suggesting a historical consistency with the current stance on assault weapons. The court affirmed that the restrictions imposed by the Massachusetts law do not create an unusual hindrance to citizens' right to self-defense. Moreover, in reference to the prohibition on high-capacity magazines, the appeal court connected this ruling with its early 2024 decision regarding Rhode Island's similar ban, indicating its likely constitutionality, which is a bunch of crap. Heller says, in common use. You cannot ban items that are in common use. The AR-15 is the most popular semi-automatic rifle in the country. It's in common use. We can expand the in common use language even further, but I'm going to keep it simple. But what they're saying here is a bunch of crap. AR-15 as a semi-automatic rifle is no more dangerous than the Mini 14, the M1A, and we know this. I could go down the list. It's no more dangerous. But once again, why do we expect a liberal court in a very Democrat area to follow the Constitution? Why are we shocked? But I'm going to come down, I'm bring you there, because this, remember I said earlier, that they came up with an opinion that blows my mind. But in affirming the lower court's denial of preliminary injunction against the ban, the First Circuit emphasized that the plaintiffs did not provide evidence showing that the banned firearms, such as the AR-15, have been utilized in self-defense situations. The court noted, for one thing, the challengers do not demonstrate a single instance where the AR-15 or any other banned weapon has actually been used in a self-defense scenario. And I have a lot of questions for these judges. Do you not watch the news? Let's go back to the LA riots. What's he carrying? And they did use them to defend themselves and their property. There have been countless cases of people using so-called assault weapons, their definition of assault weapon, to defend themselves. It's been, I can't tell you how many stories I've done on people who have used these kinds of firearms to defend themselves. Yet this court says, well, the plaintiffs didn't present one iota of proof that a so-called AR-15 has been used. And I'm like, were these judges brain dead? Or did the plaintiffs just completely drop the ball? All you got to do is go to YouTube and pull up hundreds of videos of people using these very firearms to defend themselves with magazines over 10 rounds. That, like I said, when I read that, I was stunned. But let me come out of that. But here's my point. Why do we care what these lower courts do? Depending on what area they're in, we're going to get a very pointed ruling. So why do we care what they do? It's the Supreme Court. And the Supreme Court, and I'm going to be very hard on the Supreme Court because they seem to be ducking and jiving some of these gun cases. And they need to step up. They need to jump up and get it done. Because they are shucking and jiving big time. I'm not going to deny that. But it's the Supreme Court that matters. All these cases at the lower courts, whether they win on our side or lose on our side, are irrelevant. Why do we keep bugging about them? I don't cover a lot of them because I don't care what these lower courts do. Whether it's for us or against us, I care what the Supreme Court does. And then, like I said, the Supreme Court has been kind of shuffling this stuff around and not facing it head on. And they need to. New York State versus, the Rifle Pistol Association versus Bruin obviously was a big win. But since then, they've been kind of almost afraid to touch any of these cases, but some point they're going to have to. And that's when it matters. That's when it counts. I don't care what the lower courts do. I see a lot of people making all these videos and getting pissed off at these lower courts for going against the Constitution. Why are you shocked? Why are you surprised? Look at Grant versus Lamont right here in Connecticut. Same thing. We're in a blue area. What do you think these judges are going to do? They're not going to freaking override that thing. It's got to go all the way. So I'm not even worried about what these lower courts do. Now, if a lower court rules in our favor, then that ruling stands. Cool. But more than likely, in blue states, they're going to challenge all the way because they don't spend their money to defend it. They spend your money to defend it. So there's the game. So don't get too buggy when a lower court rules against us. Who cares? Let them. It's just going to go to the next step. Just like the one in Massachusetts. That was a Massachusetts Supreme Court. So the next step is going to be petitioning the Supreme Court to hear it. That's a big deal. That just moves the ball forward a little bit. So don't get too worked up when these lower courts do dumb crap. Don't tell them they should be expelled or they're traitors. Who cares? The Supreme Court is where it matters. Let's focus on that. All of these cases are going to end up at the Supreme Court at some point in time, hopefully soon, and get this mess squared away. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I am going to see you on the next one. Peace.